Okay, let's unpack this. Imagine you're caught in a legal dispute, right? And then, sort of out of nowhere, a completely new player gets pulled into the whole thing. What happens if you think, hang on, this person shouldn't be here? This just complicates everything. Today, we're diving into a really fascinating court ruling from the Nigerian Court of Appeal. And it reveals something kind of surprising. Even what looks like a minor step, just adding a new defendant can become this whole other battleground. It's a deep dive into how higher courts work to protect the clarity and, well, the integrity of justice in a case.
Yeah, what's truly fascinating here is how this specific ruling, NEC West Africa Limited versus Prince Chukwunalu Oshiojum, it just beautifully illustrates the meticulous layers of legal procedure, all designed to ensure fairness. We're going to explore the arguments both for and against, allowing an appeal on what, on the surface might seem like just a technicality. But as we'll see, this decision actually has pretty profound implications for how a case is tried, how it's understood, and ultimately whether justice can be achieved without getting bogged down in unnecessary confusion. Our mission here is really to extract the key insights into why the higher court allowed this appeal to proceed, and what that tells us about judicial discretion, and the basic rules of engagement in a courtroom.
Okay, so our story kicks off with NEC West Africa Limited. In this situation, we'll call them the applicant. They're the ones asking for permission to challenge a lower court's ruling. But here's the twist in their initial challenge. They couldn't just, file an appeal straight away.
Yeah, exactly.
They first needed special permission, what's called leave to appeal from the Court of Appeal itself. Think of it like needing a special invitation just to get in the door before you can even start making your main argument.
Right. And that requirement for leave, it isn't just some bureaucratic hurdle, red tape. It's actually a really crucial procedural step. It's rooted in a pretty significant Supreme Court decision from back in 2017, Skelly Bank versus IWU. And that case basically dictates that appeals coming from specific courts, like Nigeria's National Industrial Court, the NICN, they require this permission from the Court of Appeal. So the applicant here, NEC West Africa, they brought their request under the Court of Appeal's own rules, and they stressed it was urgent. They really wanted it heard within 14 days of the lower court's ruling. It just highlights how important getting the procedure right and the timing is in the legal system, making sure cases move forward, but thoughtfully.
Right, okay, so here's where the plot thickens, as they say. The specific ruling that NEC West Africa was so unhappy about, it came from the National Industrial Court of Nigeria, the NICN, back on November 28, 2022. And the decision they wanted to fight, it was all about the joinder of a new party. Now, for anyone not swimming in legal terms every day, joiner is basically the legal word for adding a new person or a company to a lawsuit that's already going on, bringing someone new into the conversation, legally speaking.
Exactly right. So in the original lawsuit, Prince Chukwunalu Oshiojum versus NEC West Africa Limited, the claimant, the person suing, wanted to add NEC Corp Japan as a second defendant. Now, NEC West Africa, the original defendant, they strongly opposed this. They argued, look, NEC Corp Japan isn't our parent company. They have absolutely no direct relationship with whatever the claimant's original issue is.
Okay, so they're saying this other company has nothing to do with this specific fight.
Pretty much. But despite that, the NICN, the judge there, Justice EAOG, ruled in favor of the claimant. The lower court basically said that its own rules of court generally allow a claimant to join anyone they believe they have a claim against. So Justice OG ordered NEC Corp Japan to be joined and allowed the original court documents to be updated, calling the request meritorious. The thinking seemed to be, well, usually the claimant gets to decide who they sue at that early stage.
Okay, so the lower court says yes, add them in. NEC West Africa says no way. So they asked the Court of Appeal for permission to fight that decision. Now the Court of Appeal has to decide, should we even let NEC West Africa argue against this joinder? And I guess this led to some legal sparring.
Oh, definitely. A fascinating legal back and forth between the lawyers. The applicant's counsel, Victor Guam, argued quite forcefully. He said, look, the Court of Appeal clearly has the power, the jurisdiction, to grant this permission. He pointed straight to the Court of Appeal's own rules, which lay out the process. And he reminded everyone about that Sky Bank versus IWU case, saying it specifically allows appeals from the NICN with leave. His point was pretty straightforward. The rules are clear. The court has the authority. Just grant the request. Simple as that.
That sounds pretty logical, doesn't it? Just follow the procedure. But I'm guessing the other side, the respondent, didn't quite see it that way?
Not at all. The respondent's counsel, Francis Okiku, took a very different tack. He argued that, yes, the Constitution gives a right to seek permission to appeal, but it's not just an automatic, at-large right. He argued it has to meet specific conditions before you even get that permission. He brought up some older Supreme Court cases like Ogunkuli versus Eternal Sacred Order and mobile producing NIG UNLTD versus Monoko.
Okay, and what was the point of citing those cases?
Well, those cases emphasize a really critical point. The decision you want to appeal must have actually adversely affected you, or it must have wrongfully deprived you of something you were entitled to. So the respondent basically argued that NEC West Africa and their application hadn't clearly explained how just adding NEC Corp Japan actually harmed their interests or took away any specific right. His point was kind of like, just being named in a lawsuit or having another party added alongside you isn't automatically enough harm to justify appealing that specific decision. You need to show real prejudice.
Okay, so it's not just I don't like this, it's this decision actually hurts me in a specific legal way. Now, this is where it gets really interesting, because the Court of Appeals seems to go deeper than just ticking procedural boxes, right? Justice Oho, who gave the ruling, didn't just look at whether the conditions for leave were technically met.
That's exactly right. They really scrutinized the underlying issue itself, the joinder. They hinted that maybe the lower court had perhaps oversimplified things. It wasn't just about the procedure of asking for leave anymore. It became about the fundamental principles of who should even be in a lawsuit.
And the ruling actually says that, doesn't it? Something about joinder not being as easy as it looks.
It does, explicitly. The ruling states, and I'm quoting loosely here, that, quote, the issue of joinder of parties is usually not as easy as the court below seemed to have made it appear. Which, raises that big question. What really makes someone a necessary party? And to answer that, the Court of Appeal, interestingly, drew on some really influential English legal precedents, cases that are often considered in pari materia, basically, comparable situations dealing with similar rules, even though they're from a different system, foundational stuff.
Right, so they looked at these classic cases to figure out the core principles. Can you walk us through some of those? What makes someone necessary?
Sure. One key idea comes from cases like Amon versus Raphael Tuck and Sons Ltd., an English case from 1956. The principle there is that a necessary party is someone who'd be directly bound by the result of the action and the question to be settled.
Yeah.
Essentially, you need them there because the main questions in the case just cannot be effectually and completely be settled unless he is a party. It's not just that they might have some relevant evidence, it's about whether the whole legal puzzle can actually be solved without them. If you can sort it out without them, they aren't strictly necessary.
Okay, that makes sense. So they have to be truly crucial for getting a final answer in the case, not just sort of on the sidelines. Were there other key ideas?
Yeah, another important one came from an even older case, Norris versus Beasley, from way back in 1877. Lord Coleridge CJ clarified that if you're adding a defendant, it has to be someone against whom the plaintiff has some cause of complaint, which ought to be determined in the action. Basically, you can't just add someone randomly. There has to be a real legal issue, a genuine grievance between the plaintiff and this new person that actually needs sorting out in that specific lawsuit. You can't just, like you said, invite someone to the party if they've got no actual connection to the reason for the party.
Right. Good analogy. So it really comes down to whether this new party is genuinely central to the actual fight. But what about Nigeria's own Supreme Court? Did they have anything to say on this?
Oh, absolutely, and very powerfully, too. In a case called Arameyer and 2 ORS versus Owayemi from 1972, the Nigerian Supreme Court was really strong on this. They stated quite clearly that a party who isn't connected to the actual subject matter of the lawsuit should not be joined in the action. And here's the key part. As such a joinder will do a lot to confuse the entire case and befog the appreciation and resolution of the live issues.
Befog the issues. I like that phrasing. It paints a picture.
It really does. It's a critical warning, right?
Yeah.
What happens when you bring in someone unrelated? It's not just adding a name. It's the risk of complicating things, obscuring the real points, muddying the waters. It makes it much harder for the court to see clearly and deliver justice effectively. Like trying to find your way in a thick fog, you lose your bearings.
So tying this all back to our case with NEC West Africa, how did Justice Oho and the Court of Appeal apply these principles?
Well, they applied exactly that standard. The crucial question for the Court of Appeal became, would joining NEC Corp Japan potentially befog the appreciation and resolution of the live issues in that original case between Prince Oshiojum and NEC West Africa. And their answer was quite clear. The only way to properly figure that out was to actually allow NEC West Africa to appeal the Joinder decision itself. Now, this wasn't them saying the appeal would definitely succeed or that the lower court was definitively wrong. Not yet.
Right. It was more about the question itself being important enough to discuss.
Precisely. It was about recognizing that the question of whether this Joinder was proper, whether it could potentially confuse things, was so fundamental to the fairness and clarity of the whole case that it needed to be fully argued and examined at the higher court level.
Right.
It's about making sure the legal process itself stays focused and isn't, well, befogged.
That's a really important distinction, isn't it? The court isn't necessarily second-guessing the lower court's decision on the merits yet, but they're saying the implications of that decision are significant enough to warrant a closer look.
Exactly. They recognize that adding a party isn't just ticking a box. It can fundamentally change the shape of the trial, affect fairness, efficiency, clarity, and if there's a real risk that it could confuse the core issues, then yeah, it absolutely deserves that deeper appellate review. It safeguards the foundation of the case.
And so after weighing all of that, the procedural rules, the arguments, these fundamental principles of Joinder, the Court of Appeal made its decision.
Yes.
The application for leave to appeal, it succeeded, which must have been a big deal for NEC West Africa. Not winning the war yet, but winning the right to fight the battle, so to speak.
Precisely. A significant step. The court ordered that leave is granted to NEC West Africa, limited to file its notice of appeal against that November 28, 2022 ruling from the NICN. They give them 14 days from the date of this ruling to actually file the formal notice of appeal paperwork at the lower court's registry. And interestingly, there were no orders as to costs, which basically means each side just pays their own legal bills for this specific application. Pretty common in these kinds of procedural steps where no one's really seen as being totally unreasonable.
Okay, so this whole deep dive, it really shines a light on how these higher courts act as vital gatekeepers, doesn't it? They aren't just automatically waving appeals through. They're actually looking critically at the underlying issues, the legal principles, to make sure justice isn't just done, but it's seen to be done, and done efficiently without getting tangled up in unnecessary confusion. It really highlights that even these seemingly procedural steps, like who gets added to a lawsuit, can have massive implications and need really careful thought. It's a check and balance, really.
It really is. This case just illustrates that tension perfectly, The tension between needing to move cases along efficiently, but also needing to make absolutely sure every step follows fundamental principles of fairness and, importantly, clarity. It's a powerful reminder, I think, that sometimes the best path to justice means meticulously checking the foundations, especially who is and who definitely isn't supposed to be part of the main argument.
Indeed. This ruling really hammers home that the right way to handle a complex legal case often means peeling back those layers, making sure there's a clear, solid link, a legal nexus between the parties and what the case is actually about, and always asking, does this step help us get to the most effective and complete resolution, or does it just cloud the issue? It leaves us with a bit of a provocative thought, maybe. How often in your own life, or maybe in complex situations you deal with at work or elsewhere, could paying similar attention to the clarity of who or what is truly relevant lead to better understanding, better solutions? It's easy to let things get complicated, isn't it? To add too many elements that might just end up, well, befogging the main issue. Something to